May it please the court, counsel, good morning. My name is Peter Magnuson. I'm an Assistant Attorney General, and I represent the appellant, Commissioner of Public Safety in this case. Respondent argues here that the advisory read to him, while accurate at the time it was read, later became inaccurate based on the decisions in Birchfield versus North Dakota and State v. Thompson. Respondent thereafter concludes that his due process rights were violated under McDonald versus Commissioner of Public Safety, and that rescission of his license revocation is the appropriate remedy. The Court of Appeals agreed with this analysis. But McDonald versus Commissioner of Public Safety does not fit within either a traditional procedural due process framework or a traditional substantive due process framework. Instead, respondent argues that McDonald creates some kind of single-factor due process test.
Counsel, before you get into due process, is the doctrine of unconstitutional conditions before us this morning?
Well, no, it wasn't raised below, and this court has never applied that doctrine in this kind of case. So I don't think that it is before the court, and I don't think it would be appropriate for the court to extend it here. McDonald is a consent case. The case we have before the court right now is a refusal case. Respondent wants this court to extend the reasoning of McDonald to cover refusal cases, arguing that it's a single-factor test. Appellant suggests that it is a totality of the circumstances test, and if we're going to apply McDonald, then simply apply the McDonald totality of the circumstances case.
Looking to the Fourth Amendment and recognizing that that's the jurisprudential framework that the Supreme Court has used and that we have used, at least in some of our more recent cases, what's the best argument based on a Fourth Amendment analysis that you can make for reversing the Court of Appeals here?
Well, it's interesting when you look at the case law. When you look at all of the cases that McDonald cites, the three, State versus Lewinsky, State versus Miller, and State versus Lausanne, I believe. Byron, excuse me, State versus Byron. Those three cases are all confession cases, whether they're voluntary. And I think when I looked back at those cases, not one of them refers to the Fourth Amendment. They refer to it as a due process analysis, as did this court recently in State versus Cox. So the label that gets applied to it, I don't think is what is controlling here. It's the fact that there is a totality of the circumstances test that gets applied.
A reasonableness test.
Well, it looks at everything. It doesn't look just at the statement made by the officer. It looks at all the factors that would come into play. When you look at the factors that this court examined in State v. Cox, the ultimate issue is, was the defendant's will overborne? Now you look at this court's decision in State v. Brooks, and this exact same issue is before the court. Was the defendant's will overborne? And it looked to the same factors.
But in Brooks, the defendant took the test.
That's correct.
Well, isn't that a meaningful difference than this case?
Well, the reason that we're in the McDonald consent arena is because that's the sole basis for respondent's argument. So I would submit that the narrowest way for this court to address this case is respondent makes no procedural due process claim, makes no substantive due process claim, instead makes a claim that is all in on McDonald versus Commissioner of Public Safety, arguing that McDonald is a single-factor test that looks at one factor. Did the officer say something that's misleading? Fine. Let's take that. Now we're into it. McDonald is a consent case, but this is a refusal case. Fine. Assuming without deciding that McDonald is the correct analysis, respondent's argument that it's a single-factor test is incorrect. It's a totality of the circumstances, and if we apply the totality of the circumstances to the facts here, the revocation should be sustained.
In your briefs, I think I have the right case. I think it's in this case where maybe you do it in Morehouse too, but where you're arguing that we should apply a general reasonableness analysis.
Yes, that is one of our fallback positions.
Didn't the Supreme Court reject that, though, in Birchfield? I mean, wasn't that the very basis of the North Dakota Supreme Court's ruling that the United States Supreme Court reversed?
Yes, Your Honor. Yes.
So, I mean, we can't apply that in this context then, can we?
I would agree that the ship on reasonableness has probably sailed, especially given that the legislature now has rewritten the advisory and rewritten the whole implied consent process. That would have been a way to save it at the outset, but that's probably gone.
Counsel, looking at Birchfield, the Balin case involved an administrative license suspension hearing as we have here. And the Supreme Court applied the same analysis to that case as it did to the two consolidated cases that involve criminal refusal. So assuming that that's the test we apply here, why doesn't the holding of Thompson apply here? That because the state is trying to penalize the constitutionally protected conduct, we now know that you can refuse to submit to a warrantless blood and urine test, and you can't be criminally prosecuted for it. So why isn't a license replication a penalty that can't be done, just like you can't charge him for a criminal violation?
Well, the issue in Trahan and Thompson was a direct challenge to Minnesota Statute 169A.20 subdivision 2, which is the criminal test refusal. And ultimately, the decision was that that statute, as applied to criminal defendants, was unconstitutional with respect to warrantless fluid tests. Respondent here is not facing any criminal charges. Respondent here is facing a license revocation that came about through operation of reading the advisory, which is required under 169A.51. There has been no challenge to the constitutionality of that statute. So even though there's discussion in respondent's brief, there's a section discussing the constitutionality of 169A.20 subdivision 2, that's fine. That is unconstitutional, but that's not the statute that was motivating the revocation in this case. It really comes down to had they consented in this case, was that consent coerced, which is what the United States Supreme Court looked at in Balin. The United States Supreme Court didn't just say, look, in Birchfield, it's unconstitutional, that statute is unconstitutional, therefore, Commissioner, you lose in the Balin case. It found that we're going to go back in time, find that the advisory was partially inaccurate at the time it was read, and then remanded to North Dakota to determine, under the totality of the circumstances, whether or not the consent would have been voluntary. So that fact alone for the United States Supreme Court didn't decide the Balin case, and it shouldn't decide this case either.
In terms of deciding which method of analysis we should use, the Fourth Amendment on the one hand or substantive due process on the other, does it make a difference that Mr. Johnson refused? In other words, could you say Fourth Amendment applies when there actually has been a search? In other words, the blood was drawn, for example. But substantive due process applies when the request was refused.
Well, the interesting thing about that is then the district court, as the district court here framed the issue, the question is whether or not the officer's request was constitutional. But if we're going to apply different analyses depending on the response, well, how does that address the request at the time it was made? And I don't know of another area of the law where the person's response to the question changes the approach that we apply to the officer's request. At the end of the day, the exclusionary rule, Davis versus United States, it's not to provide a constitutional windfall to defendants. The goal of it is to punish wrongdoing by officers, and there's no allegation of wrongdoing by the officer here.
So what's the rule of law that you advocate for in this case?
You don't need to overrule McDonnell. Just say, assuming without deciding that McDonnell does apply in this case, it is not a single factor test. It did not create some new form of test. It simply applied the same totality of the circumstances test that this court has applied going all the way back to Slowinski, Miller, and Byron. Under the totality of the circumstances, there was nothing misleading. And this is different in Brooks, because in Brooks, the argument was, you made a misleading statement, I relied on it, and you coerced me into consenting. But here, there was a refusal. In spite of the fact that the officer advised respondent, refusal to take a test is a crime, respondent refused anyway. So there is no claim of, that my consent was coerced. This is all in on whether or not the officer's statement was misleading. And there's no evidence to indicate that, let's say the officer did have a warrant. There's no evidence indicating that that would have changed the result at all. I could see a situation where the officer offered blood, said, no, I don't want to take a blood test. I don't like needles.
Counsel, you may have covered this elsewhere, but I'm still not clear. What totality did we look at in McDonnell? I mean, I read McDonnell and it says you can't tell somebody something that's legally incorrect, and I can't figure out what the other circumstances were in McDonnell. Can you help me with that?
I agree it does not use the phrase totality of the circumstances, and admittedly it is a shortcut reaching to the result. But I think if it was decided today and you applied the circumstances under Brooks, you'd reach the exact same determination that under the totality of the circumstances, because there was testimony accepted by the district court that Ms. Mosier, had she not been told that refusal to take a test was a crime, which was inaccurate at the time based on the statute.
Well, I want to be honest about what we're doing. You respond to the chief that we don't have to overrule McDonnell, but and maybe that's true of the result. I mean, you're arguing that the result would be the same under Brooks. So maybe as to the result, you could well be right. But it seems as to the mode of analysis, we do have to alter it. And maybe you don't call that overruling it. Maybe you call that modifying it or going under a new strain of analysis or whatever. But I just want to be honest about what we're doing. It does require us to substantially alter McDonnell to reach the results or to reach the result that you want to reach here.
The word I would use would be clarify.
Okay.
I don't think you can read McDonnell and look at the cases that it cites to, and then the cases that those cases cite to. Every one of those cases applies a totality of the circumstances test that looks exactly at the same factors that this court looked at in State
But you
v.
do
Brooks.
agree that McDonnell seemed to just point to you can't tell somebody something inaccurate, that something's a crime when it's not, and it was sort of game over. I mean, that's what McDonnell in the ultimate analysis says.
Coupled with the fact that the driver testified, I wouldn't have taken the test but
Right.
for that statement. And that's an important fact that we don't have here.
I agree with you, and I think that might be important in the next case, but I agree with you on that. But other than that, those are the only two factors that they looked at, and the words totality of the circumstances or anything like that, those were not used in McDonnell.
No, but they do note in a cite to State v. Hild that there is no due process violation when the officer truthfully, and that was italicized in McDonnell, when the officer truthfully explains the obligations. Here, there's no claim that the officer, at the time it was read, was not being truthful.
The problem I have with that is and I understand the argument, but that is a backdoor good faith exception, in my view. I mean, what you're saying is at the time of the search, the officer was acting in good faith. And maybe that's a logical extension of Lindquist, but I don't understand us to have ever held that something that has subsequently been held to be unconstitutional is constitutional at the time because we later declared it to be, or because at the time it was constitutional. And so I guess my point is, how is that different from the good faith exception? And maybe the answer is it's not, and you're asking us to extend it, but I want to kind of get your take on it.
Well, it's interesting in this arena. Let's say somebody consents, and the court finds that the consent was coerced. What is going to be the result? The test result is going to be suppressed. Well, this isn't a criminal case where the prosecution can go forward on a separate DWI charge. Suppression of it, we all know what the end result is. Suppression means rescission. So here there's just, that step is taken out of it. Nothing is suppressed. We just go straight to suppression, or to rescission. So yes, in a certain way, there is an exclusionary rule being applied in a refusal case, and to the extent that the good faith exception would apply, yes, I think you can make that argument.
So you agree that there's at least some overlap there?
Yes, I would agree. So I would just ask the court to take respondent at their word. They are trying to shoehorn this into McDonnell. I think the court can simply say, assuming without deciding that McDonnell is the correct analysis, McDonnell is not a single factor case. It is a totality of the circumstances case. And under that test, respondent's argument fails, given that respondent offers no other avenue for support. The revocation should be sustained. If there are other questions, I'd be happy to address.
All right, thank you, counsel. You have 10 minutes for rebuttal. Mr. Koewler.
Thank you.
May it please the court, opposing counsel. My name is Dan Koewler, and I represent the respondent, Tyler Johnson, in this matter. From the outset, I don't think that respondent did go all in on McDonnell in this case. Based on how things went out at the district court level, I think this court could just duplicate the analysis, the logic, and the conclusion that came out of Thompson and Trahan, and find that just as you cannot criminally punish somebody for refusing to submit to a warrantless search, you also can't impose this license revocation on them for refusing to submit to a warrantless search. I think that the context is similar enough, especially in light of the fact that these revocations can be used to enhance subsequent behavior, especially in light of the fact that in many DWI cases, the revocation is actually a more severe punishment.
Counsel, can you differentiate for me, if it makes any difference at all, whether a civil proceeding on the implied consent versus the criminal proceeding, and if that matters?
Yeah, in this particular context, I think that it's almost a distinction without a difference. Prior case law has described this as a quasi-criminal proceeding. Cases after that had kind of distanced themselves from that language, but it unequivocally does have more than just overtones of being criminal in nature. I mean,
Well, there is certainly a significant effect on the license holder. There's no doubt about that. But what are we to do about the multiple Supreme Court references, both in pluralities and otherwise, to implied consent laws and favorable discussion of those laws? Does that have any impact on what we do here today?
I can't speak to all of that. What comes to mind is the dicta in Missouri v. McNeely, where they talked about implied consent laws. I think that dicta...
You also have it in Birchfield, too.
And I'm drawing a blank on that as well.
But anyway.
But in any event, just the fact that the Balin portion of Birchfield was remanded, I mean, that would have been the opportunity for the U.S. Supreme Court to say, yeah, this is an implied consent proceeding. That's different. Like, the same protections don't apply there. There's no need to remand this. This was fine. But instead, they did say, I mean, it was partially inaccurate. And in this context, too, the implied consent advisory doesn't tell drivers, if you refuse, you'll be facing a substantially longer license revocation. It sticks to the fact that it's telling people refusal to take a test is a crime that's going to come up in a completely separate criminal prosecution. So you've got that concern there, but the enhanceability, the fact that they can use these revocations to turn a misdemeanor level offense into a, presumptively prison-committed felony offense is huge.
Counsel, would you be here if they had asked her, I recognize that there's a question of drugs here, so that's why a breath test wasn't used, but if your client had been asked to take a breath test and then had refused, would you be here?
Probably not, because the state of the law is that you don't have that constitutional right to refuse to submit to the breath test. It's a search incident to arrest. There's no underpinning to argue that they're trying to punish you for something that would have been the exercise of a constitutional right. So I do think that in the breath context, it's a completely different argument. Like in this here, we're dealing with the two types of tests that have been held to implicate that fundamental right to say, let me see a warrant. So
Under the current state of Fourth Amendment law, if someone refuses to take a breath test, then the state can legitimately revoke their license or suspend their license.
correct, I'd concede that. Someday I may try to argue that in another capacity and regret saying that, but I don't see anything wrong with doing that. That would be the language that courts have used in the past, talking about the use of implied consent tools. And I hesitate to give that too much weight, and I call it dicta because every state's implied consent law is different. Not every state uses these revocations as an enhancing factor. There are some states that only impose revocations after somebody has actually been convicted. And it's not before this court today. It was not raised in this case, but I've still got serious concerns about the fact that we're using the implied consent procedure at all for blood and urine tests. This all started with an expectation that it was an emergency circumstance. Like
Counsel, can we just go back to this case for a minute? Your argument, as I understand it, consistently has been a due process-based argument.
Correct, based on either a per se reading of McDonald or finding that the actual sanction itself is unconstitutional because there were no exceptions to the Fourth Amendment warrant requirement that would allow the state to revoke somebody like Mr. Johnson for basically exercising the constitutional right to refuse.
Say a little bit more about the Fourth Amendment piece. I mean, I'm just looking at the headings in your brief, and they seem to be focused on a due process analysis. So where does the Fourth Amendment come in on your due process analysis?
At the district court level, it was fleshed out a little more, where if I'm recalling correctly, the judge went through all of the potential Fourth Amendment hurdles to rescission and said there was no exigency here. Clearly, there was no consent because he refused, and then found the sanction unconstitutional. Our first argument, first and foremost, is the due process argument that is mimicked in Morehouse, that, this advisory is a key component to procedural due process, and we shouldn't argue over, well, how reasonable was the advisory when it was unequivocally wrong.
Well, the answer to the Chief's question, though, is at least here, it doesn't appear, except for, at least from what I can see, and you can correct me if I'm wrong, footnote 4 on page 13, where you have 2-3 sentences say, in the alternative, we would have respectfully requested the court adopt the State v. Thompson holding and hold in respondent's favor on Fourth Amendment grounds. I mean, I didn't see it appear anywhere else. But correct me if I'm wrong, because I'm trying to figure out, as the Chief is, whether the Fourth Amendment is actually, whether you argue that in any other way, and whether it's actually before us.
And that might very well be the only place that it is raised, sort of, and I guess that would have been, in the interests of time, I know it's elaborated on a lot more in the Morehouse brief, and the way the briefing was scheduled, I filed the Johnson brief a month after Morehouse had been filed. I think there's a couple other points where I refer back to the Morehouse brief and say this was elaborated on there. But it was ruled on by the district court, and it would be a relatively clean way to dispose of this case. But we are still arguing for this court to also reinforce what happened in McDonald, what was hinted at in some of the cases that came after McDonald, like Davis, that there is a procedural due process protection that's in place by virtue of the advisory. Some of that has already been found. One part of that has been found to be mandatory, and that's the fact that if drivers need to be told, you do have this right to an attorney. And a lot of our case law has been premised on that right to counsel that's enshrined in the Minnesota Constitution. There's lots of things drivers aren't told because it's assumed that they can get that from a driver. That didn't work in this case. Mr. Johnson tried to reach an attorney for a fair amount of time. Nobody picked up. He never actually got any advice. But it doesn't change the fact the advisory was wrong. And that's the simplest way I can think to describe it.
The district court, in his conclusions of law, concluded that the advisory herein was misleading. Now, maybe it was wrong, but was it misleading?
Well, it was misleading in that it was telling Mr. Johnson, you can be punished with the crime of test refusal, when the fact is that that was unconstitutional.
But that was the state of Minnesota law at the time, wasn't it? I mean, it was a true statement of Minnesota law, wasn't it?
I can't agree to that because I spent so much time arguing the fact that once Birchfield, Thompson, and Trahan came out, I mean, it is one of those relatively rare circumstances where a substantive crime was struck down as unconstitutional. Like if you told somebody it's a crime for you to say something bad about Governor Dayton, like when this court struck that law down, which it probably would, you'd say that law was as though it was never in effect. You can't turn around and say it was accurate at the time. I mean, it's technically true, but
Was it technically true on November 9, 2015 at 11:58 p.m.?
Technically true, except for the fact that the law was still at best unsettled. I mean, it was a little bit of a gamble even at that point. I mean, after Missouri v. McNeely, the big question was, without single factor exigency, are any of these refusal laws constitutional? Blood, breath, or urine? And that question was not answered until we got to Bernard 4 years later.
Counsel, I think Mr. Magnuson's going to remind us when he gets up here that in this case, there was a refusal by by your client, by Mr. Johnson. And so it's unlike McDonald in that sense. In other words, if he was coerced, the coercion didn't work. How do you respond to that?
Two ways. The first way would be just finding that the sanction itself, penalizing somebody by taking their license for a minimum of a year for exercising that constitutional right, is also a due process violation, similar to Thompson Trahan, or identical actually. But on the other point, I don't recall if I did this more in the Morehouse brief or in this one, but I do think this court could conceptually look at the implied consent advisory a lot like the Miranda warning, where in Miranda v. Arizona itself, the court said, like, we've got this prophylactic warning in place, and if it's not used, you can't use inculpatory or exculpatory statements made by the defendant because of deficiencies in the warning itself.
But that leads to the point or the question that I just asked you, which is, in this case, there's nothing to suppress. I mean, if you were going to go down that line of analysis, because he refused the test, unlike McDonald.
And that might make it that might have been why I was raising that in Morehouse. So I guess technically you're correct there too. There is nothing to suppress other than the fact that that the fact of refusal was what led the commissioner to impose this sanction. So the only suppression, I guess, would be suppressing the use of that refusal, much as the state can't use the fact that somebody refused to submit to a warrantless search at trial.
Counsel, figuring out what is in and out of this case and what you're arguing, you are not arguing, as I understand it, that it was an unconstitutional condition to require submission to blood or urine tests as a condition of keeping your license. That's not before us, is it?
That wasn't raised at the district court level.
So it's not before us.
We didn't brief it yet on the way up, so it's not in the briefs. I do think it would be a very good alternate theory this court could adopt to support the district court's ultimate conclusion.
But it's not before us.
It's not, no, it's not before the court, but I do know this court has taken alternate theories for affirmance and used them in the past. And you're talking about the Frost v., is that unconstitutional conditions? I can't remember the full site of the case.
There's a line of cases.
There's a line of cases where, and I've raised it in the past. This court has always found it's a kind of a disfavored doctrine, but it would be on point in this case where, yeah, it's saying as a condition of your driver's license, you have to unconstitutionally agree that you no longer have a Fourth Amendment right. Similar to how this court would have ruled in, say, the Henning case, when law enforcement tried to use a statute to pull over drivers who had whiskey plates without a reasonable articulable suspicion, and that statute was struck down. But no, that was not briefed or argued at the district court in this case. But at the end of the day, I think we can all agree that the advisory itself was incorrect by virtue of the fact that it was unconstitutional to punish these drivers with the crime of refusal. I think it would be a bit absurd for us to say that we can't punish them criminally, yet we can effectively put a conviction on their record through this administrative scheme. The situation that the Freedmen Court warned us about when they found that there was a right to counsel under the Minnesota Constitution, and they warned, like, we've got some serious concerns about the legislature starting to decriminalize things and move them into the civil arena, where you don't have the right to a jury trial, you don't have the right to counsel, you don't have the right to a hearing unless you pay a filing fee and demand it. And we want to forestall the legislature doing that as much as we can. And to say that Mr. Johnson should remain effectively convicted by virtue of this license revocation when a conviction under the true criminal case would be unconstitutional would produce an absurd result, and I don't think that the simple civil-criminal distinction holds enough water in a case like this to draw that distinction. So first, I would ask the courts to find that it is unconstitutional to revoke somebody's driver's license for exercising a constitutional right. The same analysis used in Thompson and Trahan, or if the court wanted to go there, adopting the unconstitutional conditions doctrine. In the alternative in this case, I would ask the court to find that the advisory was misleading on its face, and because this is a situation where the state is pulling the trigger first and asking questions later, there's no presumption of innocence, makes it that much more important that at least the advisory is saying everything that's truthful, and here it wasn't. And so under that theory, I would also ask the court to vacate Mr. Johnson's revocation. If there are no other questions for the court, I'll be back for more House.
Thank you, counsel. Mr. Magnuson, you have 10 minutes for rebuttal.
Your Honors, I just want to cover a few topics. The civil versus criminal distinction, there is a distinction, and I think the distinction tips in favor of appellant here. We're not talking about a loss of liberty, which was potentially at stake in Thompson and Trahan. We're talking about a license revocation. And yes, counsel points out that it could be used to enhance a future case, but we're then arguing that, well, some future act could be detrimental, so let's go back now, and because there could be future charges, let's rescind this revocation.
Counsel, I tend to agree with you that there's a difference between civil and criminal. The one thing, and I actually recognize that in my concurrence in Brooks, but the one thing that gives me some pause on that particular argument is, yes, the ultimate result was revocation of a license and not criminal liability, and that matters. But the problem that I have with that argument is it was achieved by virtue of telling the defendant or the person who was losing their license that it was a crime. What's the significance of that? Yes, the ultimate penalty was license revocation, but the defendant was told that it was a crime to refuse to submit.
Well, this case is somewhat unique because it's in the gap between Trahan and Thompson, and the officer adjusted the advisory. So here the respondent was told refusal to submit to a urine test is a crime, and he was offered a blood. So respondent could have consented to the blood test, and there wouldn't be any claim of coercion, there wouldn't be any claim of improperly being threatened with charges, because he was not told that refusal to take a blood test was a crime. So he could have done that here, but he did not. And as I alluded to previously, there's no evidence that the reason he refused a blood was because he had an aversion to needles. He just simply thought he needed more time. So on the facts of this case, I don't think that's a distinguishing factor. But at the end of the day, the avenue to redress that is in the subsequent DWI. We'll hope that respondent here never gets another DWI and it's never used to enhance another offense. But if it is, certainly there can be a challenge to that as it being used as an enhancer. But because of the possibility of some future event, I don't think we should throw the baby out with the bathwater here.
Attack a prior revocation in a subsequent DWI trial. So if he was brought up in a subsequent DWI trial and you had this revocation, can you collaterally attack that earlier revocation?
Oh, yes, it's following Friedman. You know, Friedman was kind of a benchmark case. We were maybe the first state to have that as a constitutional protection. And of course, South Dakota, North Dakota, Iowa, and Wisconsin did not have it. So there were many collateral attacks that those revocations shouldn't be used to enhance because they would have been unconstitutional had they occurred in Minnesota.
Counsel, if your civil versus criminal distinction is correct, then why did the United States Supreme Court, remand in Balin? Why didn't it just say, this is a license revocation case, so this is okay?
Well, it alludes to that and I can't remember the site off of the top of my head, but as part of I think the footnote, it says that on remand, the court should examine the difference between an administrative hearing and a criminal hearing, and also examine the good faith exception. So that was certainly something that the United States Supreme Court viewed as being important.
But it also, to get to Justice Chudich's questions, and actually it relates to my earlier question, they also have a line in there that says, referring to the Balin case, they say, well, but you can't, one of the reasons why we're remanding is because you can't tell somebody that refusing a blood test is a crime when it isn't a crime. And so I'm wondering what we do with that instruction from Balin. I don't remember if it appeared in the footnote or if it appeared in the text, but it was also in that same discussion you're talking about.
Yes, and the phrase that the United States Supreme Court used was partially inaccurate. It wasn't, they didn't refer to it as misleading, it was just simply partially inaccurate, and that was just one factor to be examined as part of the totality of the circumstances. It wasn't the deciding factor.
Procedurally, or from a historical perspective, as I understand it, the North Dakota Supreme Court in Balin eventually did uphold the license revocation. Am I correct about that?
Yes, they short-circuited it, and they just asked the parties to brief, assuming there is a violation, does the good faith exception apply? And the North Dakota Supreme Court found that the good faith exception did apply, and they upheld it.
Do you know whether or not that was subsequently appealed to the United States Supreme Court? I mean, that's something we can figure out. It's not, if you just happen to know.
I have the case printed over there, so I could look to see if there was a review denied or cert denied. Off the top of my head, I don't know.
But of course, in this case, there's no evidence to suppress, right? So our current version of the good faith exception wouldn't apply here.
Well, no, arguably, the fact that they refused is the evidence that's being suppressed. This court didn't find that to be a winning argument in Thompson or Trahan. But as the discussion I had previously, the end result is the same in an implied consent proceeding. If they consent, we're simply suppressing the test, which leads inevitably to rescission of the license revocation. Here we're doing the same thing, and the supposed basis for each one of those results is based on misleading advisory from the cop, that the cop did something wrong.
Counsel, you heard my dialogue with opposing counsel about whether the advisory, the words of the advisory were correct, incorrect, accurate, inaccurate, misleading, not misleading. What's your position on whether they were technically accurate but still misleading?
Well, it's kind of it's a retroactivity question. And certainly in the Fourth Amendment context of Birchfield, the United States Supreme Court clearly says that advisory is now partially inaccurate. They didn't say misleading. They just said that the advisory read to Mr. Bayland was partially inaccurate. So that's the phrase, is partially inaccurate. But here, as I alluded to earlier, he could have, respondent could have, because the advisory was changed, he could have agreed and consented to the blood test because he was not told that it was a crime to refuse a blood test. He was simply told that refusal to take a urine test was a crime. So he could have consented to that. But at the time the advisory was read, it was completely accurate. It was in that period of time between the decision in Trahan in October and the Court of Appeals decision in Thompson in December.
And McDonald deals with an advisory that was, in fact, inaccurate, misstated the law at the time it was given.
Yes, that advisory, as read to Ms. Mosier, should not have been read in that form. If there are any other questions, otherwise, thank you for your time.
Thank you, counsel. Thanks to both counsel for the help that you provided in this case. This matter is submitted. We'll issue an opinion in due course.